In a heated exchange on Twitter, Panos Mekras, the renowned author of Understanding the Crypto Economy, clashed with prominent Bitcoin maximalist and influencer, the Vlad Costea, over the legitimacy and relevance of XRP, currently ranked as the sixth largest crypto by market capitalization. The debate ignited when the Vlad Costea tweeted a scathing critique of XRP, dismissing it as a centralized bank coin with fading utility. She expressed surprise that XRP still held its market position, attributing its popularity to unit bias and the misconception that it had ties to the banking industry. Mekras, one of the leading voices in the XRP community, dismissed the Vlad Costea's assertions and likened them to the belief in a flat earth. He expressed disappointment that such misinformation still circulated in the information-rich era of the internet. To support his claims, Mekras shared a link to his article titled Why XRP is the Most Misunderstood Cryptocurrency, wherein he provided an in-depth analysis of XRP's technology and debunked common misconceptions. He also shared a tweet highlighting the decentralized nature of XRP, underscoring that it operated on public blockchains with open source code. Furthermore, Mekras pointed to the extensive adoption of XRP in various projects, citing the XRP Ledger as a platform for hundreds of initiatives and tens of use cases. He directed attention to the official XRPL website, where interested parties could explore the diverse applications of XRP. Mekras also referred to his previous tweet, which emphasized that XRP is for everyone and was designed to disrupt banks' monopolies and create an open and decentralized payment system. Notably, the debate between Mekras and the Vlad Costea is just an episode of the numerous arguments concerning XRP's decentralization. A week ago, Ripple's CTO joined a discussion about a claim that XRP was not sufficiently decentralized. Please, do not forget to subscribe to our channel and also hit that notification bell to be the first person to get more updates about the latest happenings as regards to XRP. In the wake of William Hinman's saga, Ripple's General Counsel Stuart Alderety shared an interesting fact about how SEC officials are expected to act under the law. According to Alderety, the law requires all federal employees, especially the United States Securities and Exchange Commission staff, to act impartially. The law asks, would a reasonable person, knowing the facts, question the employee's impartiality? Alderety added. The Ripple General Counsel added that people now know the facts. He also referred to the basic obligation of public service. Notably, the section refers to the general principles that apply to every employee that may form the basis for conduct. The first section states that public service is a public trust that requires federal employees to show loyalty to the Constitution, ethical principles, and the law above private gain. Meanwhile, the portion referenced by Ripple's General Counsel states that federal employees shall endeavor to avoid any actions creating the appearance that they are violating the law or the ethical standards set forth in this part. Whether particular circumstances create an appearance that the law or these standards have been violated shall be determined from the perspective of a reasonable person with knowledge of the relevant facts. It is worth noting that the ongoing Ripple lawsuit has unraveled many hidden facts about the SEC. Recall that United States federal judge Sarah Netburn accused the SEC of hypocrisy over its litigation tactics in the Ripple lawsuit. As reported during the legal tussle for Hinman's documents, the SEC first argued that the speech is irrelevant to a market understanding about whether the commission would regulate crypto. After losing the argument, the SEC further argued that the docs are protected by attorney-client privilege, claiming that Hinman sought advice from the commission's lawyers while drafting the speech. Following the contradictory claims, the judge noted that the commission is adopting its legal position to further its desired goal and not out of a faithful allegiance to the law. Furthermore, the recently released Hinman docs suggest that William Hinman, the former director of SEC's Corporation of Finance, was partial while drafting the speech. For context, the docs related to a 2018 speech by Hinman, where he declared Ethereum and Bitcoin as non-security. Hinman noted during the speech that a token will no longer be classed as a security if it has become sufficiently decentralized. However, according to industry leaders, the documents show that the purpose of the infamous Hinman speech was to give Ethereum a free pass. Hinman's first email while drafting the speech was titled the Ether Speech. The former SEC director also met Ethereum's co-founder Vitalik Buterin a few days before the speech. These controversies have made many speculate that Hinman could have been paid to give the speech. Consequently, Ripple has called on relevant authorities to investigate Hinman to unravel the mysteries behind his June 2018 remark. Before I continue, I want to tell you something about DexPool. It's a self-composed liquidity provider, known as a market maker. It's like someone lending their crypto assets to a platform to help with the decentralization of cryptocurrency trading. In return, you receive rewards with fees generated by trades on that platform, something many consider a form of passive income, and you can get it if you use DexPool. Important to clarify that anyone can add liquidity to decentralized platforms such as Uniswap, SushiSwap, etc. through DexPool. DexPool has a welcome special sign-up bonus, which you can claim as long as you use the link provided in the video description. This bonus consists in getting up to 100 XRP. It is a 10 days liquidity bonus. The offer is limited. When you make a deposit, you will receive this bonus. Now to the big question of the day. Was Ripple's XRP ownership an issue in the SEC lawsuit? Please do not forget to subscribe to our channel and also hit that notification bell to be the first person to get more updates about the latest happenings as regards to XRP. A recent Twitter thread by John Deaton, a pro-XRP lawyer and founder of CryptoLaw, shed light on the potential ramifications of a safe harbor proposal by the US SEC. Deaton suggested this proposal could have brought clarity to the crypto industry and potentially prevented the legal battle between Ripple and the SEC. Like the one presented by SEC Commissioner Hester Peirce, a safe harbor proposal would give token issuers a grace period to develop their network free of federal securities laws under certain conditions. Drawing attention to the SEC's primary concern, Deaton proposed that if the regulatory body had focused on Ripple's percentage of ownership in the outstanding XRP token, it could have set a specific time frame for Ripple to reduce its holdings and meet the predetermined threshold. The observations made by Deaton stemmed from his conviction that the absence of explicit guidelines and a safe harbor framework has hindered the United States from keeping pace with the rapidly evolving crypto landscape. Highlighting the importance of a safe harbor proposal, Deaton pointed to a meeting on March 28, 2018, between representatives of venture capital firm Andreessen Horowitz and former SEC Director Bill Hinman. He underlined that, before the meeting, a 16Z had submitted an extensive memorandum proposing the safe harbor, originally tailored for Ethereum but with potential applicability to other tokens. According to Deaton, it is possible that this particular safe harbor proposal influenced the subsequent introduction of a similar proposal by Commissioner Peirce in 2020. She presented a second proposal with 3 modifications in April 2021. Deaton emphasized the potential benefits that a safe harbor approach could have brought to Ripple and LBRY, among other crypto-focused companies. These firms could have received a notice outlining specific criteria necessary to demonstrate decentralization, giving them a 3 to 5 year window to meet these requirements and establish their tokens as commodities. Such regulatory clarity would have paved the way for compliance and facilitated innovation. While Deaton acknowledged that not everyone would have been satisfied with the proposed guidelines, having a well-defined framework would have allowed companies like Ripple to work towards meeting the requirements within a specified time frame, thereby fostering both innovation and regulatory compliance. According to Deaton, the absence of a safe harbor proposal, coupled with the lack of clear parameters regarding token ownership, has contributed to the ongoing legal dispute between Ripple and the SEC. As evidence of Ripple's commitment to defending itself against the SEC's allegations, Deaton cited Ripple's voluntary decision to reduce its XRP holdings to fund its legal fees. Had the SEC established a clear threshold for token ownership, Ripple could have gradually reduced its holdings over 3 to 5 years, aligning with the prescribed limit. Deaton's arguments also raised questions regarding the role played by former SEC Chairperson Jay Clayton and former SEC Director William Hinman in perpetuating regulatory uncertainty within the cryptocurrency industry. The lawyer emphasized the significance of recognizing their shared responsibility to understand why the United States lags in providing a supportive and unambiguous regulatory environment for the crypto space. So we come to the end of this video, guys. If you enjoyed it, please make sure you like the video. Don't forget to subscribe and hit the notification bell. This really helps me with the YouTube algorithm. Also, you can help enlighten others just like you have been enlightened by sharing this video to as many people as possible. Let's get this news everywhere, guys. If you are a true cryptocurrency fan, don't miss any of our content. See you tomorrow to talk about the latest news that concerns us all as a community.